All right. Well, good afternoon, everybody. And thank you all so much for the happy birthday wishes. Today is my birthday, and it's actually a big one. Pretty big birthday, I think, for myself. And therefore, I appreciate all the love, all the happy birthdays I'm seeing in the comments, all the happy birthdays I got on X and Twitter, and the comments in my comment section. So I very much appreciate everyone wishing me a happy birthday. It is a big one, and it's not exactly 30. In case you were thinking that I look 30, I'm not 30 at all, but I'm not 50 either. So we still have a few years before that. But it is the big 40. As I see, Melanie Gore has guessed it. I don't know how you guessed it from some of this white hair coming down from my beard. Maybe that's how. But yes, it is the big 40. So thank you all. Still, I guess 40 is the new 20, they tell me. So that's exactly the story that I'm keeping with. So that is what we're going to be talking about. All right. So that is in terms of the birthday issue situation. Thank you all. It's been an interesting ride so far. I still feel very young. And yeah, so I do want to talk about the Karen Reed stuff. I actually also wanted to talk about some, normally we have a Q&A with the members only. And everybody who's a member of the Brother Counsel Sidebar, they send me questions. And we usually have a special members only video addressing those questions. But I guess in honor of the birthday, let's do it in more of a public forum this time. And we'll go through some of the questions that were submitted by the members. And some of the questions are a little off of the Karen Reed stuff. Some of them have to do with the Karen Reed stuff. But okay, so before we get into the questions, though, I really want to talk about what happened so far in the Karen Reed case today, because there was some news. I wasn't expecting it. And in fact, I was just going to talk about, being 40 and all of the tremendous life experience that I have being at age 40, but because of the Karen Reed stuff that came up, so let's talk about the order, the opinion that just was dropped, and I know that we're also waiting on another opinion. So let's just kind of take a step back and talk about some of the orders that just recently came in. And by the way, thank you very much. Before we get started, we got Programmer gifting 10 Brother Counsel Sidebar memberships for a great way to start off the 40th year of my life, I guess, with some more Brother Counsel Sidebar memberships. So we're going to talk about, yes, I see some questions about, can they appeal the Easter decision? Let's talk about the Easter decision, and then we'll talk about whether they can appeal it. The short answer is yes, they can appeal all these orders. Anything that Judge Cannoni rules can be argued on appeal if they feel that they have a basis to appeal it. Now, the more serious question, or the more real question, is whether they're going to have any chance on appeal, because again, it has to do with the standards of review. What's going to be the standard of review? All of these decisions that she's making now are essentially, I think it mostly comes down to an abuse of discretion standard. When it talks about being evidence that's admissible has to do with an abuse of discretion standard, generally speaking. There's always exceptions, but I think most of these do not fall into the exceptions. But yeah, so most of it's abuse of discretion, and it's a very, very high standard to meet. So a lot of these decisions that she's making, as even if it's not such a close call, it will still be upheld on appeal. So it doesn't mean that they can't argue it on appeal, but they have to prove that it's an abuse of discretion, which is an extremely high standard to meet. But let's get into the Easter decision. I'm gonna pull up the order. Like, I don't read all the orders, verbatim, the entire order and the entire opinion, but we're going to talk about a little bit. And also I want to talk about some other orders that came out. So number one, let's talk about an order that came out recently over the weekend, and that is the manner of death. So we know that this was a motion that was argued by Elizabeth Little. I thought that she made some pretty good arguments, some compelling arguments. And the reason for that is that, generally speaking, in Massachusetts, the manner of death is not allowed to be on the death certificate when you're presenting it as evidence to the jury. You're not allowed to have the manner of death being a homicide, an accident, or suicide. So you're not allowed to put that on the death certificate. So the question was, what about when it's undetermined? What about if it's undetermined? Is undetermined allowed to be on the death certificate? And by the way, I just noticed in the chat we have Sojourner who's the first time here. Well, there's got to be a first for everything, so appreciate you coming on for the first time. Hopefully be the first of many. So let's continue. So there's a question about undetermined, whether undetermined can be allowed in on the death certificate. And if you just look at the case law, where generally speaking, it talks about how the manner of death is not allowed to be on the death certificate, generally speaking, well, then you should think that that applies also to when it's undetermined. However, there was definitely a compelling argument made by Elizabeth Little that for undetermined, at least, there's no specific case that says undetermined is not allowed to be on the death certificate. And I thought it was a compelling argument because the reason why you don't want these classifications on the manner of for the manner of death on the death certificate is because it's kind of taking the ball out of the jury's court, because the jury is supposed to determine whether this is a homicide. The jury is supposed to determine whether this is an accident. And therefore, if the death certificate says homicide, well, then the jury is going to be told essentially that that's what the medical examiner found and that's how they should find. So that's why you take it off. But when the manner of death is undetermined, well, then you're not telling the jury what to do. It's just saying the medical examiner couldn't figure this out. Maybe you as the jury could figure this out. So that was the argument essentially, and that is what Judge Cannoni actually found. So she actually did rule in the defense's favor for that specific order, that the manner of death, as it relates in this case, where the fact that it's undetermined, will be allowed to be on the death certificate and will be allowed to be argued to the jury. So now, remember, that's also helps the defense in terms of their argument. They're going to be arguing to the jury, look, the medical examiner couldn't figure this out herself. And now the Commonwealth had to hire this neurologist or this neurosurgeon to tell you. In most cases, you just rely on the medical examiner. So why shouldn't this be like most cases? And it's undetermined, which means that you don't know yourself. So as a jury, that's reasonable doubt. So that's definitely a good argument that they can be making now, that the manner of death is listed as undetermined, and that will go to the jury. It's admissible. So that was a significant part of one of the orders that came out recently. Okay, now there's another order that I think just recently came out. Before we get to the Easter stuff, we'll get to the Easter stuff in a minute. But there's another order that came out with regard to the ARCA experts. As you know, the ARCA experts, there was a motion that was filed that the defense should be able to tell the jury that the ARCA experts were hired by the federal government. And the reason for that is that they don't want the jury to speculate why the ARCA experts got involved. Were they hired by Karen Reed's insurance company, her auto insurance, her home insurance? Are they trying to make a name for themselves? Is that why they're brought in? Did Turtle Boy hire ARCA experts for some odd reason to come into this case? So they don't want the jury speculating. And when the jury speculates about how ARCA got involved in this case, and all the judge is going to allow them to say is that, we didn't hire them. Well, how did they get involved? And even though you tell the jury, don't speculate, don't think about these things, well, that's what the jury does. So if the jury's going to do that, it's going to prejudice Karen Reed. It's not fair. So that was the argument why the defense should be able to tell the jury that ARCA was hired by the federal government. That's how they became involved in this case. So now you have an answer to that question. You don't have to speculate. And also, it helps because the defense looks like they may be hiding some information from ARCA. When it's brought on in cross-examination, what materials the ARCA experts did not have, it sounds like the defense maybe had something to do with that. So that's also something that's not fair for the jury to speculate why they did not have certain materials, and for them to blame the defense by not providing these materials. So that's another argument that was made. However, what seems to be, and I did not see this order come through. I just got I see some information on the docket that there's an order that she is denying that motion by the defense. So I don't see any more order. If you guys do see the order while I'm talking, let me know about it in the chats and we'll try to pull it up. But I did not see the order come in. So that's in terms of the ARCA experts. Okay, so now let's move on to the Easter order. Okay, now you guys will remember that I spoke about this issue about whether the defense can provide an expert witness to talk about police investigation and what's the appropriate policies and procedures. So what are you supposed to do? So those type of experts, should they be admissible in Karen Reed's case or not? Now, we spoke about this. We did a video about it, and we also pulled up some law. I actually tweeted out from a case law, some case law, which would help the defense. So let me read for you this part of the order, just part of the order, which I think is interesting, which is the most relevant part. And then we're going to talk about this a little bit more. All right. So let's pull this up. I hope you can all see it now. If you can't see it, let me know in the chat. All right. So this is what Judge Cannoni says. Now it's a little bit of a more of a lengthy order, but this is really where I think the crux of her opinion analysis is. In support of her Bowden defense, the defendant here seeks to admit expert testimony from Michael Easter, a retired agent of the Federal Bureau of Investigations, FBI, to opine on law enforcement's failure to adhere to standard investigative policies and protocols in this case. We all know about the problems, the myriad of problems with the investigation. More specifically, Easter's expert report indicates that he will testify that the investigation in this case was not reliable due to the lack of secured crime scene, absence of a detailed crime scene log or evidence chain of custody, the failure to separate witnesses, and the premature categorization of individuals as witnesses. Okay, seems like to be a direct quote from his report. Unfortunately, we did not get to see his report, but that seems to be a direct quote from his report. And potentially biased based on the failure to investigate other suspects and obtain their cell phone records. So this is Easter report at 1516. So there's more in there that we can't analyze because we don't see it. The court cannot find, nor has defense counsel cited one Massachusetts case where an expert was permitted to opine on the general competency of a police investigation. Remember, this was the issue. And this is what Judge Cannoni gave Alan Jackson some homework. She said, here, this is your homework. Find me a Massachusetts case that allows an expert to talk about the competency of a police investigation. Now, I tweeted out a case, which I thought would be very helpful for the defense. But that was his homework. Now, he said that there is some case law from other jurisdictions. There's perhaps some federal case law. But the question was, can you find me a Massachusetts case which actually shows that you can allow an expert to testify as to the competency of a police investigation? So the defense did submit a brief on this issue, and they did cite some case law. However, what was absent from the defense's motion and from their brief was my case, the case that I tweeted out. So maybe they didn't see my case, or maybe they chose not to include it. And we're going to see why I think that was a big mistake. They should have included my case. I know what I'm talking about, right? You got to follow brother counsel's advice, but they didn't do it. So look at footnote number 1. Okay, so again, this is really the reason the court cannot find, nor has defense counsel cited one Massachusetts case where an expert was permitted to opine on the general competency of a police investigation. The defendant cites Commonwealth versus Wood. This is the footnote. You know how much I love footnotes. The defendant cites Commonwealth versus Wood, where the Supreme Judicial Court noted that the defense counsel, through cross-examination and the calling of its own expert, extensively challenged the adequacy of the forensic investigation conducted by the police. And then they quote the site here. Now, what's interesting about this site is that this, you see where it says N16? That means footnote 16. So this is actually a footnote quoting a footnote. So you would think I'd be in heaven right now because you got footnotes quoting footnotes. That's just the great, right? Anyway, so that's the citation that the defense cited in their brief on this issue. That Commonwealth versus Wood, it's a Massachusetts case, but in that case it was talking about that the defense was able to call an expert to challenge what? The adequacy of the forensic investigation conducted by the police. There's a reason why brother counsel didn't tweet out this case, Commonwealth versus Wood, because it's not the greatest case on point. It's also a footnote, even though I love footnotes, but you're always better to find some citation from the actual body of the opinion. Nevertheless, that's the citation that they quoted. So what does Judge Cannoni do with this? So Judge Cannoni has a very easy job. All she has to do is distinguish between Commonwealth versus Wood and the situation that's in front of her. So what she does is the court acknowledges that some forensic matters are beyond the common knowledge of jurors and therefore appropriately explained by expert testimony. That is not what the defendant is seeking to present through Easter's testimony. And that's right. She happens to be right here. Commonwealth versus Wood, they're talking about forensic investigation. So you're talking about, like DNA, you're talking about fingerprints, you're talking about blood spatter analysis, you're talking about things that you, generally speaking, need an expert to explain. And therefore, if you have your own expert to say how the detective, the investigation, the police investigations forensic unit wasn't as good as your expert, and your expert saying that they should have done it differently, they should have collected the evidence differently, and that's going to affect the forensics on this case. Okay, there's Judge Cannoni saying, okay, there I understand why there can be why you need an expert to show why the police's expert and their investigation didn't do a good job. But what about here? Here we're not talking about DNA evidence. We're not talking about blood spatter analysis. We're not talking about those type of things. We're talking about just in general the investigation, talking to witnesses, ruling out witnesses, bias and prejudice throughout the investigation, chain of custody. This is not like a forensic expert that you need. This is just in general how the investigation is conducted. So it was an easy job here for Judge Cannoni to distinguish Commonwealth versus Wood. Okay, now, so let's just continue the opinion. I'm going to show you my case that I said they should have cited, and we're going to be able to then see whether Judge Cannoni would have been able to make that distinction from my case. All right, well, let's continue. The lack of authority suggests that during all the jury trials where the defense has been inadequate police investigation based on Bowden, expert testimony has not been needed for the jury to be able to evaluate the reliability of the Commonwealth's case and whether any failures in investigatory steps are sufficient to create a reasonable doubt of the defendant's guilt. Easter's proposed testimony concerns basic aspects of a police investigation which are within the common knowledge of a lay person. Through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures, and can raise the issue of potential bias by police action or inaction, as counsel did effectively during the first trial. So she's saying, look, you can still cross-examine on this, all these issues that you have, the solo red cups, you can make them look like a bunch of fools by doing it, and the jury's going to understand. They don't need an expert to say you cannot collect evidence with solo cups, right? So you can really get everything that you need by just cross-examining their witnesses, and it'll be obvious to the jury that this is not the best way to investigate a crime scene or a murder. So that's essentially what Judge Cannoni is saying here. But I really want to concentrate on this distinction here, because this is really what it comes down to. She said, find me a case. They did their best. They tried to find this case, Commonwealth versus Wood, and Judge Cannoni was very easily able to distinguish it. Now, what part of your job when you're a lawyer is you're trying to show a case which is going to be much harder to distinguish. You want to show a case that's more directly on point. Don't just show me a case where the defense was able to call an expert, which would cast doubt on a police investigation. It depends what that expert's talking about. They're talking about something like DNA, they're talking about a medical examiner or causation or things like that. Okay, fine. That's understood. But you're trying to apply that to your situation. So I'm just going to do this again, just because you can see this for yourself. I said that they should have quoted this case, Commonwealth versus Silva Santiago. Now, in Silva Santiago, what happened here was that you had this professor, this assistant professor of psychology, as you see here. And she testified about what? Procedures. These are procedures that were recommended by the United States Department of Justice in its publication, and they were not followed by the police in this case. We're not talking about forensic evidence here. We're talking about a lineup. That was going on in this case. In this case, Silva Santiago, we're talking about an array. We're talking about where the person was asked to pick the defendant out from the lineup. And this is a guide. This is a guide for law enforcement. This is a publication about how you're supposed to do lineups. First, the witnesses were not told before viewing the photographic arrays that the culprit may or may not be present in the array. Without such an instruction, she testified, a witness tends to assume that the culprit is present and proceeds to make a choice from the array. This is all based on this publication. Second, the witness should have been asked how confident they were in their identification immediately after making them, because some research shows that a witness's confidence in the accuracy of his identification grows once he learns that the police believe he made the correct identification. Third, the identification procedure should be fully documented, preferably by a videotape or audio tape recording. This is literally policy and procedure when it comes to a lineup. That's literally what this is. And here they allowed an expert witness. Now, I know it was a psychologist, so it's not exactly who you want to call in this case, but would Judge Cannone be able to say, oh, well, this is a case that talks about forensics? And therefore, of course, yeah, when you're talking about that type of detailed expertise, then of course we will allow you to have an expert. But you're just talking about in general terms about policies and procedures or standards of investigation and those techniques. Where do you ever find a case that allows the defense to hire an expert? Well, this is it. This is exactly it. That's what this case specifically says. It's not talking about forensics. This is just about a lineup and what the proper policies and procedures should have been and what the standards were. And she was allowed to testify. So I'm just saying, got to trust brother counsel. And they did not cite by case. They did not cite. They instead cited Commonwealth versus Wood. Okay. Well, anyway, so that is that's what the order on Easter is. Therefore, she's not allowing Easter. And yes, it'll probably be part of the appeal, but the question is whether that appeal is going to be going anywhere. Not exactly so sure. Okay, so let me see if we've got any other questions here before we move on, because I do want to get to the questions that we have on this, because this is supposed to be a Q&A, but because of the recent developments in the news, so we got to talk about that. So let me just pull this up here. We've got from D Brown 83. I love your channel. Happy birthday. You are so great at explaining the docs and cases. I loved your brother too. Now there's one of the questions, I may as well just jump ahead to the questions because I know that my brother made a pretty big splash here. This actually was not the first time he was on, but here. Okay, here's a question that was submitted by one of the members from the Brother Counsel sidebar. And it was the following. Is Solomon your real brother? Okay, because apparently people were not sure since I call myself Brother Counsel. So maybe this is just me calling another person my brother, even though he's not really my brother. It's just maybe that's how lawyers talk about each other, Brother Counsel. So maybe this is my brother and he's not really my brother. So the answer to that is yes, he is my real brother. He's also my Brother Counsel, but he is my real brother. So I've represented him in court. We're talking about like traffic ticket. And he's represented me in court, so we have fun with that. But yes, he is my brother, and I assure you that he is going to be making some more appearances with me on this channel. Definitely, maybe we'll talk about the Easter order, this order that just came out. Maybe we'll talk about that. So we'll talk about some other orders that are coming out. But yes, he's definitely going to be joining here on the channel again, hopefully soon. So let me see what we got here. We've got a member for 9 months, Nikki. Nikki's one of the greatest. She always retweets my tweets, so we appreciate you, Nikki. Tagged you in third-party culprit decision on X. A third-party culprit decision that she. Oh, did that just come out now? Third-party culprit decision. Okay, here's a question before we move on. Before appealing, can defense do something to these denies? Not really. They can file a motion for reconsideration, as we know, but that's most likely going to get denied as well. So there's really not much to do about all these orders coming out now. So it looks like the. Let me see if I can even pull up the third party decision here. There's a third party culprit decision. I'm not sure what it was about. So I'll have to pull it up. I'm assuming. Okay, if anyone can put in the chat what exactly she ruled, we can talk about that a little bit. But whether she's going to allow the defense to argue the third party culprit, I imagine that she's going to see how the evidence comes in. Maybe not allow them to open on it like she did last trial, but I can't say for sure. But if you do know if that's what she said in the order, just post it in the chat and I can confirm with everybody that that's what she did. Okay, but in the meantime, because I would love to see the third-party motion, by the way. If somebody can email it to me, brothercounsel99@gmail.com, I will pull it up right now as we're talking, as we're going through some of the questions. I'll pull it up right now. We'll go through it real time as the first time I'm getting it. So please, if you can get it, definitely email it to me right now, brothercounsel99@gmail.com, and I will take a look at it and pull it up right now as we're speaking. So let's see. Okay, so let's move on for the meantime. I'll keep checking my email as we go through this. So if any of you can just download that and send it to me, preferably in a PDF, that would be very helpful. I'll pull it up for everybody. We'll go through it. In the meantime, let's go through some other questions that I got, and we'll move on to the Q&A about from the members. Okay, so we're going to kind of do this in the public sphere, even though some of these questions are a little personal. But you know what? It's my 40th birthday, so let's get a little personal. Question: why are you covering Karen Read so much, especially when it's so toxic? So here's the reason why I think Karen Read, I'm spending a lot of time covering Karen Read, and I've covered a lot of other things also. I've covered Donna Adelson. I've covered a lot of this. I've covered some stuff on Brian Koberger. We'll get to that more probably when Karen Read's case is over. But why am I spending so much time on Karen Read, especially that it's so toxic? People are very strongly on both sides, and you post anything that people don't like, they immediately try to trash you and troll you and do all these things. So why is it important for me to cover? Well, here's one thing. I do know that there are certain YouTubers that are not covering Karen Read because of the toxicity, because they've tried it. They've put their little pinky toe in, and they felt the water and it's too hot, so they ran out. And I understand that, because I guess it can hurt your channel, I guess, maybe if you are just a general YouTuber, you're not a law tuber, you're just a general YouTuber, and you want to keep things kind of fair and down the middle, and you don't want to annoy anybody or piss anybody off too badly. So the reason why I think that it's important for specifically lawyers, and I'm a lawyer, so the reason why I think it's specifically for lawyers to cover this case and not run away from it, despite the backlash that you may get, is that there's obviously something very different with the Karen Read case. Okay, any lawyer that looks at this knows that there's something different with the Karen Read case, and there's some questionable orders, as we've spoken about. There's some questions of bias. There's some questions of prejudice. There's some questions of police investigation where it's not just a creative defense attorney making an argument about the police investigation not being done well. There's some serious problems with this case. And I think when lawyers look at that, and the lawyers that I've spoken to about this case, and when I tell them some of the details about this case, you should see the reactions. It's very different than your regular case, which is why I think, despite the water being so hot, and despite that people may get upset at what I say, but for law tubers who are covering cases, this is a case that demands lawyers to look at. And especially if you can be a little bit divorced from the actual Boston area. I'm in Michigan. I don't have any intimate connections with Boston, so I can kind of approach this as an outsider and an objective outsider. I think it's important for a lawyer. This is what we stand up for. We stand up for truth. We stand up for justice, and we want to make sure that everything is as good as it can be. And it's supposed to be, the system is supposed to work. Most of the time it does. And we want to make sure that it stays that way. So I think as a law tuber, you have a duty to cover this case, to cover this case. And if as much as you can help people understand what exactly is going on, and to help them understand why this case is so novel and so unique, and not like your regular standard criminal prosecution, I think it's important to point that out and help people understand that. So that's why I think, even though I understand that I've definitely gotten some backlash from this case, and people posting all types of things about me, who knows, and saying things about me, and anti-Semitic stuff also. But I still think as a lawyer, it's important to cover it. I just think it's too important to cover as a lawyer, definitely coming from a lawyer's perspective, to cover this case, which is why that's why it's taking up a lot of my time. And by the way, I am covering other cases also, because one of the other questions that I got here is, what other cases are you looking at opining on? Donna Adelson by any chance? So this is actually, yes, one of the cases that I'm looking at is Don Adelson. That's a case I've been covering since Charlie Edelson's case, and that's definitely a case that I continue to follow, and I put out videos on that also now. If something's coming out on the channel, something's coming out on the docket, I try to put out some stuff about Donna Adelson as well. So I'm looking at Donna Adelson. I'm covering that. I know that case very, very well. So I am, it's easier for me to cover than, let's say, Brian Koberger, which I did do some analysis on the death penalty issue because it's a very interesting legal issue that was argued. So we did some analysis about that, but I'm not as intimately knowledgeable with the Brian Koberger case as I am with the Karen Reed and Don Adelson case. So I think with Brian Koberger, I'm going to have to kind of wait until Karen Reed kind of finishes, and then we'll jump into everything going on with Brian Koberger and try to, be in the best position to understand everything and break it down for all of you. So that's what's going on there. And if there's questions, by the way, put them in the chat, please, so I can get to them. And if anyone has sent me the email, that would be appreciated of this order. Here's a question. Do you have any regrets about covering the KR case? So I guess that's kind of piggybacking off the last question. And the answer is that no, I don't have regrets, because I think that it's the responsibility of any lawyer who has any sort of following to be able to break this stuff down and explain what's really going on, or because this case is so novel. And if something happens to you on the way, if I become unpopular because of it, well, then that's what happens. I mean, you're a lawyer, and as a lawyer, we all kind of understand that we're trying to stand up for truth and justice, and this is what we have to do. And this case, I think, demands our attention. And if you can help other people with understanding what's exactly going on, especially when you have a case like this, I think that you have a duty to do that. And if you become unpopular because of it, well, then fine. Then don't advertise yourself as a law tuber. Advertise yourself as a regular YouTuber, and then you can cover whatever you want. Take only the popular positions or whatever, and do it that way. But I think if you're marketing yourself as a law tuber, you're saying that you're a lawyer, and you're coming at this from a legal background, and that's how you're trying to educate people. Well, then I think you have a responsibility really to cover this type of case. So here's a question from Honey Bunny. Does Solomon play hockey too? I can imagine you both in the rink. The answer is that yes, Solomon actually plays more hockey than I do. He is, well, right now he's a little bit injured, but he was the one actually who really got me into ice hockey. When we were both in high school, he's a year and a half older than I am. So we were in the same school, and he was the one that really started getting into ice hockey. And I just followed in his footsteps, because that's what younger brothers do. So I followed in his footsteps, and then eventually we started playing in leagues together. And but at some point he was playing so much more than I was, and he's better than I am. Truth be told, he's better than a hockey player than I am, and I'm happy to admit that. So he's a better ice hockey player than I am, and that's just what it has to be. So I'm not sad about it at all. You can't tell. Here's a question from Sharon McCarthy. Brother Counsel, do you know if Hank Brennan is bringing up prior clips from interviews Karen did in the first trial? Does that open the door for the defense to bring up the first trial? Thanks. No, I don't think it opens the door to bring up the first trial. Exactly how Judge Cannoni is going to deal with that, the jury's not going to be allowed to know that there's a first trial. So they will be able to say at a previous hearing, maybe, or you previously testified to that effect. But the jury's most likely not going to be able to hear that there was another trial. So even though there's going to be interviews about Karen Reed and what she said in the interviews, but I think anything that has to do with first trial, or that there was a first trial, is not going to be allowed in. That's my thinking on that. And here's a question again, Anthony Nancy. Will you be bringing your dad and your brother again back on your channel? So yes, my brother is coming back. My dad I have to work on, because he's not, he's a little technologically behind. So I'd have to figure that all out, but that shouldn't be too much of an impediment. We'll get him on eventually. We'll have to get him on. We don't work in the same office. If he worked the office right next door, I'd be able to set him up very easily, but we'll have to figure it out. Here's a question, raining like the weather. Since Easter is denied, why can't defense get a copy of the procedures/policy manual for CSI and ask the investigators, did you do this or that, and list them every instance in their closing? So they could do that. If they did not have the policies and procedures or standards, if they have some sort of document like that, they could use that. That's exactly what they could do. So yes, they are allowed to do that. And if they can show that they did not follow certain policies or procedures, then they can definitely argue that in closing argument. Absolutely. Okay, I'm trying to get through it here. Okay, so now let me just see if anybody sent me. Okay, I do see that somebody sent me the PDF. So give me a second here. I'll pull it up right now and we'll go through it. Great idea. It's not that long either, which is great. Okay, let's pull it up. Give me 1 second here. All right. Thank you for sending it to me. Here we go. Hope you all can see it. This is the first time that I am actually reading something for the first time in front of you. Usually I like to read it first, make sure I understand it, analyze it, maybe do some research. But here we go. This is the first for everything. So maybe in honor of my 40th birthday, we'll do this. Okay, here we go. Memorandum of decision and order on Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. The Commonwealth has moved to preclude the defendant from raising a third-party culprit defense. The defendant has alleged 3 potential third-party culprits, Brian Albert, Brian Higgins, and Colin Albert. For the reasons that follow, the Commonwealth's motion is allowed in part and denied in part. The opportunity to present third-party culprit evidence is guaranteed by the Due Process Clause of the 14th Amendment because it is rooted in the right of criminal defendants to a meaningful opportunity to present a complete defense. A defendant may introduce evidence that tends to show that another person committed the crime or had the motive, intent, and opportunity to commit it. However, the defendant's latitude to introduce such evidence is not boundless. The defendant's ability to mount a third-party culprit defense is not without limits. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that it has substantial probative value and will not tend to prejudice or confuse the jury. Let's see what she says about Colin Albert. All right, Colin Albert. As to Colin Albert, the defendant's proffer contains no additional evidence than that presented at the first trial, and it is insufficient to support a preliminary finding that Colin Albert had the motive, intent, and opportunity to commit the crime. Now, I think, like I told you before, I think that Colin Albert is the hardest to convince the jury that it was part of the third-party culprit. I mean, in terms of motive, opportunity, intent, and evidence that he had something to do with, he was probably the most, the hardest one to get in the door for third-party culprit. The evidence of opportunity is wholly inadequate. There's no evidence that Colin Albert was at 34 Fairview when the defendant and Mr. O'Keefe arrived at the home. Third-party culprit evidence properly excluded where there was no evidence third party had means or opportunity to commit crime, and evidence of motive was speculative and too remote. Evidence at the first trial was that Colin Albert had already been picked up by the time O'Keefe and the defendant arrived at 34 Fairview, right? That was the evidence. The testimony was that Colin Albert, although he was there before, but he left before John O'Keefe and Karen Reed arrived. That was the testimony in the first trial. As to motive, the defendant contends that Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to O'Keefe's death, and that Colin Albert had thrown beer cans on O'Keefe's lawn and swore at him. There was, however, no evidence substantiating these claims at the first trial. Even if there was evidence of some ill will between O'Keefe and Colin Albert, motive alone is not enough to demonstrate third-party culpability. And then they say here, to the extent And remember looking at the footnote here, because you know how much I love footnotes, to the extent that at the upcoming trial, the defendant would offer hearsay testimony to support the claim that Colin Albert had a feud with O'Keefe. To be admissible, such evidence must be otherwise relevant, not tend to prejudice or confuse the jury, and there must be other substantial connecting links to the crime. Meaning, like we spoke about before, hearsay evidence is allowed if to prove a third-party culprit defense. So if there may be some sort of hearsay testimony that there was some sort of feud between John O'Keefe and Colin Albert, still, it's not enough just to say that there's just a feud. What she's saying is that there has to be other substantial connecting links to the crime. The proposed evidence does not provide a substantial connecting link between Colin Albert and O'Keefe's death. And then she cites a case here that the fact of tensions between the neighbor and the victim was not indicative of the neighbor's motive to kill, and the defendant offered and produced no evidence suggesting that the neighbor had any opportunity to kill beyond that possessed by any neighbor. This was a case, I think, that Brennan argued. Buckman. Yeah, we went through that case if you are a watcher of this channel, and if you're not, you should be. Definitely a subscriber of the channel. But we went through that case, went through Buckman, and Buckman, there was some sort of feud between the neighbor in that case and the victim, and that wasn't enough to bring them in as third-party culprits. Moreover, the theory that Colin Albert is the third-party culprit because he had scraped knuckles at some point after O'Keefe's death, had been seen in a video drunkenly taunting others with no connection to O'Keefe. I was talking about the hockey team, and apparently was not named in police reports, is speculative at best. Third-party culprit theory that victim was shot by an unnamed rival drug dealer was based on rank speculation and properly excluded. So just the fact that he did have some scraped up knuckles in some picture at some point after John O'Keefe's death, that's not enough either. That's not enough evidence to show that he's really a third-party culprit. Also, that he was taunting this other hockey team when he was drunk, apparently. So that's also not enough. And the reason that he was not named in police reports, conveniently left out of the police reports, again, that may go to the investigation in this case. That may go to the Bowden defense. But in terms of third-party culprit, that's where there's much more a harder connection. Evidence that rival gang members live. Okay, that's citing another case. Allowing such feeble third-party culprit evidence possesses a risk of unfair prejudice to the Commonwealth and would only serve to confuse the jury. Accordingly, evidence that Colin Albert is a third-party culprit is excluded from trial. The Commonwealth's motion limiting is allowed as to Colin Albert. So there's no surprise there, at least for me. I've told you from when I saw this motion and when we discussed the hearing that, again, the hardest person to connect to this third-party culprit defense is Colin Albert. So here's Judge Cannoni agreeing with that, and therefore, third-party culprit evidence is not allowed for Colin Albert. Now let's get on to Brian Albert and Brian Higgins. This is where it's going to be harder for Judge Cannoni to deny that there may be a third-party culprit here. As to Brian Albert and Brian Higgins, the defendant's proffer is barely sufficient. Barely. And the history of the first trial casts doubt on the seriousness of the claim. However, to protect the defendant's right to a fair trial, and in recognition of the fact that the defendant has no burden to prove anything under our law, the court will take the same incremental approach as it did the first trial. Defense counsel are ordered not to mention potential third-party culprits in opening statements, but counsel will be allowed to develop the evidence at trial if possible, and counsel may seek an appropriate instruction if warranted after the evidence is concluded. Though the court may ultimately exclude the proposed third-party culprit evidence or counsel may abandon the theory, that does not mean that the defendant cannot offer the evidence to show the inadequacy of the police investigation, provided that the proper foundation has been established. Let's see what footnote number 2 says. The court notes that the defendant at the first trial, under an identical order, did not seek an instruction on third-party culprits. So, coming back here, so therefore also this is another part of this motion that we have to remember. It wasn't just about whether you can provide evidence of third-party culprit. The same evidence that you want to provide as third-party culprit defense, you can also provide as a Bowden defense. So really, this is what Hank Brennan really wanted. Hank Brennan really wanted that they should not be allowed to provide any evidence, number one, as third-party culprit, and number two, even as a Bowden defense. Remember, Bowden defense is the defense that the police investigation was wholly inadequate. So he wanted them not to be able to present any sort of evidence for any purpose. What Judge Cannoni is very clearly saying here is that as it relates to Brian Albert and Brian Higgins, they are allowed to produce all this evidence. They're allowed to provide and offer and admit all of the same evidence that they want to use as a third-party culprit defense. They're allowed to admit that evidence under the Bowden defense to show that there's an inadequacy in the police investigation. So all the evidence is coming in. The only question is going to be, number one, for a jury instruction to the jury about third-party culprit. And number two is if you're going to argue to the jury specifically that Brian Albert and Brian Higgins were the ones that committed this murder. And like I said, I'm not sure if that's the greatest approach anyway. I'm not sure if that's what they need to do or want to do. If all the evidence comes in anyway, then why not just leave it up to the jury? Say, look, I don't know who did this. Somebody else did it. I don't know who. So don't argue that it's a third-party culprit, specifically Brian Higgins or Brian Albert. We'll see if Judge Cannoni allows them to argue that as well. Therefore, it is hereby ordered that the defendant is precluded from raising a third-party culprit defense alleging Colin Albert is culpable for John O'Keefe's death. The Common's motion is allowed as to Colin Albert. The defendant is not prohibited from raising a third-party culprit defense as to Brian Albert and Brian Higgins at this time. Counsel cannot mention potential third-party culprits in opening statements, but will be given the opportunity to develop the theory through relevant, competent evidence at trial. The Common's motion is denied as to Brian Albert and Brian Higgins. Now, something else you have to notice here is that what is she not allowing the defense to argue in their opening statement? What exactly? Okay, and this is what, when you're a lawyer, it drives you a little bit crazy when you don't have specific instructions. What she's saying here very clearly is that let me see, where does it say here again? I say very clearly, but I've just lost the place. Counsel cannot mention potential third-party culprits in opening statements, which to me seems that all you're not allowed to do in opening statement is to mention Brian Higgins and Brian Albert. But can you say that she's framed? Why not? You will still be in compliance with this order. If the order is just telling you you're not allowed to mention specifically Brian Albert and Brian Higgins, that's all you're not allowed to do in opening statements. So then you can say, look, there could be a whole array of people that we don't know who committed this crime. If only the police would have done their investigation properly. If only they wouldn't have shielded their own. If only they wouldn't have just stuck it on Karen Reed and framed her. So can you make that type of argument? Why not? Again, from the order, it seems very clearly that they cannot mention potential third-party culprits. But to say in general terms, somebody else did this. We don't know who it was. Somebody else did this. I mean, I think, according to this order, that you could. So I'm not surprised by this order. I think it was going to be very similar to what we spoke about. And therefore, Colin Albert, it's out, which I think anyway is not the greatest third-party culprit defense anyway. And then Brian Albert and Brian Higgins are still potentially still in. So that's with that. All right, let me see if there's any more questions here. We do have a nice donation from Sharma Lily. $5. Happy birthday, brother Counsel. Thank you very much for all the happy birthday wishes. I'm telling you, what else would I really do with my time instead of spending it with you on my birthday? So I think that's a good one. Okay, if there's any more questions, I'll put them in the chat. I was not looking at the chat before now because I was reading that order that just came out. But I see that there is another birthday here. Also, happy birthday. We are off to celebrate my son's 16th birthday today. Well, happy 16th to him. March 31st is just it's a great day for a birthday, let me tell you. Here's a question from Nikki. And Nikki, I think thank you for sending me that order. Is it normal that Judge Cannoni openly voices her disbelief in the defense's theory in her rulings? She did the same with Russell. I don't know why she's doing that. I know that she did that with the Crosby order, and I know that she did that with I'm sorry, not the Crosby order. Yeah, Dr. Russell. I think she also did that with her motion to dismiss, with her order on the motion to dismiss. I thought that was to me off the charts. You're going to start mentioning how Brian Higgins not necessarily was talking on the phone. Who says he was talking on the phone? Maybe just holding it by his face because that's a comfortable place to keep your phone until you get a call or a text message. So I don't know why she's doing that. I don't think it's something that you see all the time. But it's just another thing about this case. Tara, new sub, loving your videos. On the bumper here, I read a DNA article stating the here was in only a loose match. Any O'Keefe's male could have left it. Okay, interesting. That it could have been by any O'Keefe, not just John O'Keefe. Could have been Paul O'Keefe. So I guess, I mean, the question is, how is that going to help the defense at all? By that it could have been any O'Keefe. Yeah, I guess it says that it could have been anybody. Anyone's here could have been there, not just John's. It's most reasonably that it's John's hair, and it was just either placed there or it got stuck there because he's around her car. After all, she is his girlfriend, so makes sense that he's hanging around the car. And remember that hair stuck on that back bumper while it was being towed in a blizzard for like how many miles? It was towed and put on the tow truck, taken off the tow truck, and somehow that hair just stayed there and never left that bumper here. So the magic here, the magic bullet, and now the JFK files are all getting, released to the public. So now we got the magic here. Question: can they still question him about his bloody knuckles from bracing himself from a fall? Shaking my head, or no, now that's third party out of him. Yes, Chris, I believe that you're right, that that they are not going to be allowed to ask him about those the knuckles. The third party stuff is out for Colin Albert, which means also that video about threatening that fight with the other hockey team, I think that's out as well. So yeah, I think that all that evidence is out. $60 miles round trip. That's how long that the magic here stayed on the back of the vehicle for. Okay, wait. I want to get to some other Q&As that came in, and if there's more Q&As, put them in the chat. But I do want to get to some other ones. Okay. Somebody mentioned something to me today on X about being an Aries, that I'm an Aries, and that was very shocking to them. And I'm not exactly sure why. Maybe somebody can put in the chat why that is. I think maybe because some personality differences of Aries, but somebody put that in. Now, there are some questions here that are off of Karen Reed. And question that I said I'm going to get to today is actually this jersey that's sitting in the back. Okay, so what's this jersey all about? So this jersey is that there's a RCCS tournament. It's a hockey tournament that I play in, and I was we raised some money for that hockey tournament. It's a charity. It's RCCS, which helps people that have been stricken with cancer, and they help the families out and provide a resource and hold their hands. And it's a very, very special organization. And they have a hockey tournament, a couple of them a year, but depending where you live, that's who they focus on. So it's really once a year for me. I love to play in it. I love to raise money for them because they're a very special organization that help families that are stricken with cancer. So I've played for them. And this past year, that was our jersey. So I got an extra jersey. So the extra jersey is sitting right there, and it says Brother Counsel on the back with number 1. So that is, no, I'm not a goaltender. I play forward. I don't play defense. And that's the extra jersey that I got. I'm still trying to figure out what to do with it. Maybe we'll have it as as a giveaway on our channel or something, or maybe we'll do it as a raffle. If you want a Brother Counsel jersey, a hockey jersey, it's a very cool jersey. So maybe we'll do something with that. I'm still trying to figure it out. Maybe you guys can give me some ideas what to do with it, and we'll figure that out. Okay, let me see another question here we got. Shelby Vasquez, what are your thoughts on the defense delaying their opening statement until after the Commonwealth has rested, if allowed in Massachusetts? So sometimes you are allowed to defer your opening statements until after the Commonwealth has rested. What do I think? I think that's a terrible idea. I would never do that in this case. They're going to be hearing weeks and weeks of testimony from the Commonwealth. So as the defense, I think in this case, you definitely want to let the jury know why your evidence is going to show something different than the Commonwealth's evidence. The Commonwealth's going to be putting up all this evidence. They're going to hear about the reconstructionists. You want to tell them about ARCA. You want to say, ladies and gentlemen, you're going to be hearing some evidence from the Commonwealth's biomechanical engineer. And he did a reconstruction on this case. And you're going to be hearing the following of his conclusions. But you should also know they're going to be hearing a very different opinion by some extremely qualified experts that were hired by ARCA, who do work for the NHL and for the U.S. government. That's generally who they work for. So, keep that in your mind as you hear the evidence come in. So I think that would be a better approach, and I think that's exactly what we're going to be seeing in the trial. I do not think that they should wait until the Commonwealth is finished with their evidence. Do you have mods yet for the channel? Andy School, how would you today's rulings? I do have a mod. I do have one mod right now who's doing such a fantastic job. Her name is Blurry Lights. So she's handling the chat and moderating. How would you today's rulings? I'm not sure what the question is, but I thought that with Colin Albert, I thought he was going to get out of the third-party culprit defense, as you know. The ARCA experts, which I heard came down that they're not allowed to mention about the federal government. I understand that ruling because I understand why Judge Cannoni does not want the jury to hear about the federal government. And she's going to have to deal with how is this going to bias or perhaps prejudice Karen Reed. But I can understand as a judge why you would not want the jury to hear that the federal government is somehow involved in this case. You would not want the jury to hear that, and it's going to open up the door for a lot of speculation, even more speculation. So I understand it. What do you want from me? Sorry. Here's a question. Do you believe me now that the judge is biased? Like I said, I mean, that order on Crosby, what got my brother, Solomon, what got him a little enraged about this case was because of that order on Crosby. And comparing that with the order of Dr. Russell, it's very difficult to reconcile. How is the same judge making these same rulings in the same case a week apart? How does that make any sense? And it doesn't. I don't have any sort of explanation on it. So I'd love to hear an explanation, but that's where you start to think that why is the judge doing that? Why is it so clearly a difference between Crosby and Dr. Russell? And that's why, my brother said his opinion very strongly, which I completely understand. I don't have other explanations. I'd love to hear Judge Cannoni try to explain the difference in those two rulings. How tough do you think of all these denied motions make it for the defense to get an acquittal? Is it insurmountable at this point? No, it's not insurmountable at all. If ARCA's in, then that is your ticket. I mean, that's really Karen Reed's ticket to freedom. As long as the ARCA experts can testify, that is going to, I think, create reasonable doubt. Now, again, like I said, we have to see the trial. We have to see how the evidence comes in. We have to see how Dr. Welcher does. If Dr. Welcher can get up on the stand and explain very clearly how the ARCA experts are out of their minds and how all of their equations and physics and science and math are all garbage, and they're not doing the appropriate math and they're not doing the appropriate reconstruction, and he can show that very clearly, well, then you may have a problem. Now, are we going to see that? Probably not. But if he can actually do that, then it would be really helpful for the Commonwealth, and it would be very damaging for Karen Reed. But as long as Karen Reed is going to have those ARCA experts and they're going to be able to testify very clearly and very confidently, and they are extremely qualified, then no, I don't think anything's insurmountable at this point. So. Okay, I'm still trying to get through some of the questions here. And just to stress this point from Melanie Gore, they could somehow let the jury know that ARCA wasn't hired by this side. Yes, that's true. That is going to happen in this case. She will be, the judge will be allowing both the defense to say that they did not hire them. They will have to say that they hired them for this case to testify, but specifically that they were not hired to do the reconstruction. I think that is fair game. I think that's what Judge Cannoni is going to allow them to do. Here's a question. Can the defense ask the judge directly to explain herself, or does this go against protocol? Are you talking about the difference between Crosby and Russell? I'm assuming that's what you're talking about. Can you ask the judge for more clarification? Sure, you can ask. Is she going to do it? Probably not. She's going to say, look at my orders. I don't have to explain anything more. That's part of the reason why Robert Alessi filed that motion for reconsideration, because he wants the judge to either, explore this more on the record. Now, she may just say the motion for reconsideration is denied. See my orders. Most likely she will do that. But if she really wants to do the right ruling, correct her ruling, she should correct her ruling. And she should either hold a Daubert hearing in the middle of trial, like she did with Dr. Russell, and she's planning to do with the ARCA experts, and then take it from there. That's what she should do. She wants to correct herself and make herself look a lot less biased. Besides motion for recusal, are there any other options if you have a judge acting as second prosecutor? And the answer to that is no. And my brother will tell you that there are many judges out there like that act as a second prosecutor. And there's not much you can do, and not much you can do about it. So, no, there's not much besides asking for her to recuse herself. Nothing more really to do. I mean, you can complain to the Judicial Tenure Commission. That usually goes nowhere because they're able to, they're smart enough. They're not dumb. Okay. Judges, like my brother says, the judges that are acting like second prosecutors, their rulings will still reflect that they're not completely abusing their discretion. They will give some wins to the other side also. They're smart people. Okay. You're not going to one up them. So, they just may lean and bend one way, and they can, back up most of their rulings with some reasonable argument. There's not much to do, unfortunately. Here's a question, only in Cannoni's court. Will the inverted video be allowed to be shown or mentioned to this jury? I believe absolutely. Okay, I believe absolutely the inverted video should be able to be shown to the police that this is what you turned over to us. You inverted the video, and they should be able to argue that to the jury. I think absolutely that should be able to come in. Even if now they're correcting it, still, this is what was produced to us. This is what you, as part of your investigation, produced to us. I think that has to be admissible, and I think it is admissible. Now, what Judge Cannoni is going to do, I don't know, but that I think absolutely under the rules should be admissible. Kay Schmidt, happy birthday. Appreciate your neutrality. I get dragged every time I say Hank Brennan is greatly skilled and know exactly what he's doing. Well, I will tell you that somebody left me a comment today saying that once my brother and I said that Hank Brennan is a skilled lawyer, so they're never watching my YouTube channel again. That's part of the risk of sharing my opinion and telling you the truth. And I'm sorry, but I tell you the truth. And the truth is that I've dealt with many lawyers. My brother has dealt with many, many lawyers. I think any lawyer out there who's going to say that Hank Brennan is not a skilled lawyer is just pandering. I don't think he's telling you the truth, or she's telling you the truth. He is a skilled lawyer. Now, you may not like him. You may think he's slimy. You may think that he's doing things that are not ethical. Maybe you can argue those things, but to say that he's not skilled at what he's doing, to say that he doesn't know what he's doing, that's what I'm talking about. He knows how to try a case. He knows how to argue a motion. He knows how to write a motion. Okay, I'm reading his briefing,
It's very well done. It just is. Now, you may not like him, and you may not like the way that he sounds, and you may not like him because he's on the other side, and he's prosecuting this case. And a lot of people would say you shouldn't prosecute this case. But in terms of skill, in terms of, is this a lawyer that knows what he's doing? Is this someone who can go head to head with Alan Jackson? I would say yes. From what I've seen, yes. Okay, so that is my opinion from my experience with dealing with many, many, many lawyers throughout my career, and my brother's opinion with dealing with many lawyers is that you're looking at somebody who knows what they're doing. You're not looking at someone who doesn't know what he's doing. He knows what he's doing. He's skilled. Now, you may not like it, and you may think that he shouldn't be acting a certain way, and maybe he's slimy, and maybe that's what, maybe you'll argue that. But my opinion is still that you're dealing with somebody who is a skilled lawyer. And if I had to rank him or Lally, I would put him above Lally, which is, again, my opinion, that why I think he was chosen and hired to prosecute this case, because I think he's better. So I'm sorry, but that's my opinion, and that's my brother's opinion. And I think that any lawyer that's gone against other lawyers in hearings, in trials, and knows what the other side is like, and knows when you see a good attorney, when you don't see a good attorney, I think that they would agree with me. And if you don't agree with me, then maybe they haven't been in court in a while. I don't know. But I know it's not a popular opinion, but that's the opinion. I give you my opinion because that's what I do on my channel. You don't like it, I'm sorry. Okay, the questions about can they appeal Easter, I've answered. They could appeal Easter. All these rulings they could appeal. And by the way, here's just another question. The Gamer Burger, happy birthday. Thank you for sharing your wisdom. Did you see the Nicole Rice trial? The defense had an FBI expert on. Yeah, I mean, we've seen experts talk about investigations before. We've seen that. So I don't think there's anything wrong with it. I think that Easter should have been allowed to testify in this case. And I actually showed you a case which was very comparable, where an expert was allowed to talk about investigating techniques. So I think that Easter should have been allowed in, and I think it's a mistake, but again, not an abuse of discretion. I don't think this is a winning argument on appeal. I don't think they're going to win on appeal on this. They'll argue it if she gets convicted, that is. But it's an abuse of discretion, which is a very high standard. So. Can defense ask judge to recuse this since this is a new trial? Not really. You can ask them. Once a judge says they're not going to recuse themselves, how many times are you just going to ask the judge to hate you? So they're not going to. So forget about that happening. Okay, we're trying to get down to the other questions here. I know there's a lot in the chat, so we'll get there. Okay, I'm still trying to get down to some of the questions here. A lot of happy birthdays. So again, I appreciate all the happy birthdays. I know this. I always get this question about thoughts on chances of convictions now, mistrial versus not guilty across the board. And I think I'm telling you guys, you really have to wait for the trial. You all know my opinion about after the first trial. I like to wait to see all the evidence, and then I can give you my opinion. I waited in the first trial. I saw all the evidence, and it was clear to me that there was reasonable doubt. So she should have been acquitted. Now, what's going to happen in the second trial, I don't know. But like I think, like I've been telling you, it really is going to come down, I think, a lot to Dr. Welcher. It's really going to come down to, I think, a lot of that, how he's going to try to explain how this interaction happened and whether it's credible or not. And really, I think he has two jobs. Number one is to show that. Number two is to debunk the ARCA experts. He can't just get up there. If he just gets up there and explains how this happened without debunking the ARCA experts, and the ARCA experts get up there and say, I'm sorry, physics and science do not agree with Dr. Welcher, now I think that's going to be some pretty reasonable, strong case for reasonable doubt there. But if Dr. Welcher can get up there and explain how this happened very clearly and say that the ARCA experts just don't know what they're talking about, very clearly say that, and their analysis is flawed, then not as a good look for Karen Reed. Anna Banana, is there any point where you tell your client that there's a high chance that they may lose the case? Okay. The time when you talk about their chances of winning is when there's usually a deal on the table. Okay. So when there's a deal on the table, there's a deal being made, you tell the client, look, I got to tell you, looking at the evidence in this case, I don't see such a great case for you. You very may well get convicted if we fight this. Here's the deal. This is the deal on the table. And it's up to you. But I can just tell you as a lawyer, doing this before, this may be a good, something that you should consider, because I really want you to consider this, because I think that our chances of trial may not be that great. Now, once that offer is off the table, or if you rejected the offer, then you try to be optimistic. You tell them, look, we're going to try our hardest. We're going to do our best. And we are going to try, we're going to try to beat this case, and you try to stay optimistic. But when you're not telling them that there's a deal on the table to be made, when you're not trying to convince them of that, why would you just, destroy their hopes and dash their hopes? And I really don't know this question, but since it's your birthday, what's your favorite birthday choice? I'm not sure what that means. What's my favorite birthday choice? Here's a question, Dirty Bev. Are you watching daily and recapping? I know you have a holiday coming up. Just asking. Thank you. So I'm assuming you're talking about when the trial gets underway. I think the trial may actually get underway after the holiday, after the Jewish holiday is over. So I should be able to watch that. I think we may live stream the trial if we can. If I have a clear schedule that day, then why not live stream it? And I'll have to catch up on all the work either before or after any other work that I have on my cases. So I'd like to live stream it. If I can't, then I'll definitely be watching it and recapping it and giving you my analysis of anything that happens. And of course, I would love to get my brother on to talk about some of the days of trial also. So that's also part of it. Oh, favorite birthday gift as a child that you remember. Okay, since it's my birthday, so let's talk about birthday stuff. My favorite birthday gift as a child. I'll tell you something that really sticks out in my mind, which is really cool. When I was younger, so my dad was a lawyer, as you guys know. He was working for a firm, and the firm would have, I don't know if they had season tickets, but they had some sort of package of season tickets to the Red Wings. And my father, I somehow got the tickets for my birthday. And I was really young. I don't know, maybe I was 10 years old at the time. And my father told me I was like getting ready for bed. Like, we had maybe a cake or something, a little party in the house. And then I was going to get ready for bed. And my father said, hey, I just want to take you somewhere real quick. So I was like, should I get into pajamas first? Should I not get into pajamas? So he was like, no, just come. I want to take you really quick. So I'm like, okay, fine. So I was like, where's he going? You going to take me to 7-Eleven, maybe get a Slurpee? Like sometimes he would do that. So he took me in the car and he started driving. And like, I was like, this isn't really quick anymore. Like, I wonder where we're going. And I had no clue. I was like, should I tell him that I'm still in the car? Like, does he remember that he took me in the car now? Where is he going? And I was like, where are we going? And he's like, don't worry. We should be there soon. And he takes me downtown. at the Joe Louis Arena at the time. That was before it moved into Little Caesars. And he parks and we get into this. He doesn't tell me a thing. He doesn't say a word. He just takes me downtown, gets to parking, and we go on this people mover. And then we eventually end up in Joe Louis Arena without him saying a word to me. And he just takes us to our seats and we sit down and we watch the game. So that will be always a very memorable birthday. So that was a great gift. You know, I have a big family. We come from a family of 9. And for me to be able to go with my dad alone, just me, nobody else, and to go to get these good seats and watch the Red Wings, I think they won. It was really, really cool. So. Here's a question from Christina Maria, just to explain how this all works. How can the judge say that Colin was not involved, apparently as a fact? Isn't that something the jury should consider? She seems more as a witness than a judge. So, no. So the way it works with third-party culprit specifically, when it works with third-party culprit, is that you want to introduce evidence that this other person actually was the one who committed this crime. So it's very different than a regular defense that you have the right to put on. This is you trying to introduce evidence that it wasn't you that committed the crime, but it was somebody else. So it's like inculpatory evidence against somebody else. Really, if you think about it, what does Colin Albert's video of him threatening this other hockey team have to do with Karen Reed's guilt or innocence? Right? The only way that comes in is to say that Colin Albert was the one who committed this murder. So that is the only way that it gets in. And that's with third-party culprit, and that undergoes a specific analysis in the law, whether you can start introducing other evidence. Like, can you bring in any sort of evidence of any investigator in this case to show that they did anything wrong? You know, it gets into character evidence. You know, why would you be allowed to bring some evidence like that in, or bad acts? So only if you're able to not tie that person directly to the crime, then you can somehow get that person in for third-party culprit. Favorite birthday cake choice? Is that what you meant? Okay, favorite birthday cake choice. I happen to like chocolate. Okay, I just like chocolate. So chocolate cake, I'll take that over vanilla every time. So I like chocolate cake. I like chocolate ice cream. If it's got chocolate in it, I probably like it. So that's what I like there. Pro Gamer. Feds provided evidence Karen Reed is not guilty to the Commonwealth, and then they just watch the Commonwealth continue prosecuting. Really? I think they're still watching just how far the corrupt actors will go and how many they can catch. So I guess this really comes back to the question of whether the federal investigation is actually over or not. Is the federal investigation over or not? And, you know, there's no manual or policy procedure exactly how the federal government goes about telling people when their investigation is over. Now, did they call the Canton Police Department, the Massachusetts State Police, and say that I just want to let you know that the investigation is over? Yeah, I guess you're gonna have to take their word on it. You know, so that's the question: is it really over or not? I don't. As from what we've heard, they haven't told the defense about it. So I don't know if you believe the prosecutors and you believe Hank Brennan and you believe that they actually called the police, the Canton Police Department, said it's over, and therefore it's over. Then fine. Are they still watching? Maybe. So I just don't know. It's possible. This is probably my favorite post so far. Happy 21st birthday, Brother Counsel. Thank you for everything. I think I remember when I was 21 still. Just a few years before. Okay. So there are still some more questions I didn't get to, which is really a little bit off the beaten path. So if you want to stay and listen to these questions, this is really for the members. So here we go. I'm in my third year in law school and have aspirations to one day open my own law firm. Can you advise me on that? Should I start a YouTube channel? So let's take one question at a time. You want to open your own law firm. So I actually opened my own law firm pretty soon after I became a lawyer. And the reason that I did that was I was able to. The reason I was able to is that I had a very, very strong grounding in law, meaning since I was 4 years old, my father, who's a lawyer, was taking me around everywhere. I would read everything. He would teach me the process. He would teach me how to file things. I knew a lot more than the average lawyer graduating law school and getting his passing the bar. So that's why I was able to open my law firm very soon after. There's two parts to opening a law firm. Number one is that you really have to know everything from top to bottom in order to open a law firm. You can't just be good at research. You can't be just good at writing. You can't be just good at trial work. You have to really know the annoying things, like the procedures, like how to get something on the docket, how to file something, so you just have to know all of the annoying things that a lot of lawyers actually don't know. Some of the lawyers are just good at writing briefs and arguing them. If you'd ask them, how do I file this? How do I send out a subpoena? They wouldn't know. And that's something that their secretary or legal assistant does, or their paralegal does. So you really have to know everything from A to Z. Another thing is obviously you have to have some way to get clients. So if you want to open up your law firm from day one, how are people going to know about you? How are people going to be able to trust you? How do they know that you actually know what you're doing? So you have to figure that part out also. So what I would say is that if you're just starting out and you want to start out with from law school and you want to start opening up your own firm, I would say first, learn everything. So go work for a regular firm, whichever area that you want to specialize in. Go work in that firm. Learn everything from A to Z. Ask them to do everything. And the best thing would be actually to work for them as a law clerk. So if you know everything from A to Z as a law clerk, and when you go in as a law clerk, don't just try to do certain things that you like. Do everything that you don't like. You want to learn how to do this from A to Z. So make sure you know it. That's what you're supposed to be doing when you're in law school and clerking, to know how to do everything, not just what you're good at and not just what you like. And then after that, you go work for a regular firm, get used to the work, see if you can build up some relationships and network. And then after a couple of years, then that would make more sense to then begin opening your law firm. So I don't suggest what I did. It was a very different course, but I have a very different background. So that's in terms of that. I'm dating a lawyer. What should I expect? Okay, so the first thing that you should expect is that you're not going to win another argument. Okay, so if you don't like winning arguments, don't date lawyers. Don't marry lawyers. Okay, but that's just a joke. No, what you should expect is that most lawyer jobs are stressful. Okay, just understand that. Whether you're working for a big corporation or big corporate law firm, whether you're working for a small law firm, the lawyers work hard usually. You don't get your cushy job until many, many years after you already started working. So definitely in the beginning, if this is a younger lawyer, he's probably going to be working very long hours, and it's a stressful job, which means that there'll be less time probably for you, definitely in the beginning, and that you have to make the time count. So it has to be quality time. So make sure that you're scheduling quality time, and that quality time should be without any sort of distractions, without answering emails, without making phone calls. It should be just one-on-one directly with you. Also is that because of the high stress being a lawyer, before you get to the fun stage, like where I am, I guess, but before you get there, there's a lot of stress, and lawyers have different ways of blowing off stress. Okay, and you have to make sure that if you're going out with a lawyer, that they have healthy ways to blow off their stress, because there are some lawyers that during the day they are sharp, they are great, they do a great job, and then in order to blow off some steam, they do some things that are not so healthy and that you shouldn't be doing. And you have to make sure, like I play ice hockey to blow off some steam, so that's a nice, healthy, good way to blow off some steam. But that's something you just want to make sure of. What do you do to relax? What do you do to blow off steam? And if they don't have a good way to do it, then there may be some red flags there. So that's in terms of that. Otherwise, it's a great profession, and they're very noble people that are doing it. People believe in it, and just be ready that it's a lot of work, and you have to really believe in it. And they need a lot of support. They need someone who's going to really be in their back corner, helping them and encouraging them and supporting them through it. So, okay, there's probably a lot more to talk about that, but that's going to have to do for now. Let's see what else we have here. Okay, well, what was the funniest thing you've ever read? Okay, so I did used to read some funny books back then, but over the time, I've just been watching some more funny things. And I don't know if you've all seen this, but the comedian that really gets me laughing on the ground and fits that I can't handle is Brian Regan. Okay, Brian Regan just, if I ever need a good laugh, just put in some Brian Regan and I'll just start laughing hysterically. So he's absolutely my favorite comedian. Okay, let me see if there's any more questions here in the chat. There's one more here, just a comment here. Alina Rafferty is hallucinating or lying about, I guess, talking about the federal investigation being over. So, okay, so we've gone on for a little bit of a while now, and I appreciate everybody joining us today, and I appreciate all the happy birthday wishes. And I wish you all the same, that you should have only happiness in your life. Get a good chocolate cake to enjoy, or chocolate ice cream. That would be best. Some chocolate cake and chocolate ice cream. I'd be in seventh heaven. So I appreciate all that. Appreciate all the love. And until next time, that's going to be it for today. So we'll keep watching the Karen Reed stuff. Jury selection is supposed to start tomorrow. Should take a little bit of a while, which is good for me, as you know. But in case more things are coming out, we will definitely be analyzing it. So that's it for now. Thank you all for joining, and we will see you next time.